yet. Lehman Brothers collapsed. Bernie Madoff was exposed. The subprime mortgage market exploded. Families across the country lost their homes and the equity they had spent a lifetime building. All this together became the Great Recession. President Obama got elected on a promise to rein in Wall Street's abuses. In 2010, the Dodd-Frank Act was signed into law. Many people believed accountability had finally arrived. But my next guest is here to tell us that wasn't the full story. There's another scandal, one that was hiding in plain sight. It may be even worse than what we saw in 2008. So, without further ado, I'm going to welcome in Mark Anderson. Mark, thanks for joining.
Hey, Ben. Thanks for having me, man.
This is long overdue. So, for those of us that don't know, I've known Mark for, I think, over a decade now.
That's right.
Mark is a close friend and a valued colleague. We've worked together in many, many cases. So, Mark, why don't we get started? Tell us a little bit about your background first.
Sure. I'm Mark Anderson. I'm a partner at Anderson Bowman Walshine PLLC, located in Kew Gardens, Queens, and also in Melville, New York. And I practice primarily commercial litigation and real estate litigation.
And you're forgetting one important thing, Mark. You're a Minnesota Vikings fan, isn't that right?
I am an oppressed Vikings fan.
So you grew up in Minnesota, and how did you make it over to New York?
I went all around the place. I went to undergrad at the University of Wisconsin. I met my wife shortly after going to undergrad. We ended up going to law school in the DC area. She went to Georgetown. I went to University of Baltimore. Something we have in common.
Yes.
And
so
then
you were dating while you were in law school. What was that like?
It was interesting. I mean, she was my LSAT teacher, so it was.
That's
she's much smarter than I am. Yeah, that's the only story. That's the story. But no, we ended up getting various jobs during law school in New York, and we ended up just liking it here. And this was in law school. It was a tough time during the Great Recession and everything else. So we found jobs where we could, and eventually I found a job at Stevens Zalewski and Associates. And then it kind of plumed into a bigger thing, which was it became Anderson Bowman Zalewski, and then a whole bunch of other incarnations, and now it's Anderson Bowman Walshine.
Wow, that's quite. But how did you come from Minnesota to Baltimore to New York? What was that journey like?
Oh man, it was a lot of work, a lot of stress, and a lot of not knowing what I wanted to do with my life. When you go to law school, there's very few people that know what they're going to specialize in. I certainly didn't, and I got here and I kind of learned the things that I just was given at the time, and I just kind of found a niche in foreclosure and consumer litigation and real estate.
So I think that's what everyone really wants to hear about. They don't want to hear about the Vikings. So
I'll talk about it if you want to.
So let's get into this story. And I know it's been blowing up. I read about it on the Gothamist, and then there was a podcast, and it's been really making the rounds. So your firm just filed a big class action lawsuit against a lot of major banks. So tell us what is going on. What is this scandal really about? And why don't you break it down for us?
All right. So we practice a lot in foreclosure defense. And a lot of times what ends up happening in these cases is there's kind of a lack of judicial oversight, especially at the end of the case. And no one's really paying attention. And so what ended up happening is I got a visit from one of the class representatives, Sheila Badar, who had a case where it turned out that there was a bid on a property that went to auction for $775,000, and the bank purported that the bid was, through a whole bunch of different legal wranglings and everything else, that the bid was actually 210,000. And so I noticed that Sheila and her mom, Ruth Athel, were deprived of about $500,000. So then I looked even further into it, and I realized that certain portions of the calculation were wrong. And so
Wait,
our
so
office,
let's back up a second. There was a bid submitted. It was supposed to be for 700,000, and then
785, I believe.
$785,000, and then someone, instead of bidding 785, gets a property for 200,000, and the rest of the money we don't know where it went.
It's crazy. Yeah, we have no explanation for why it happened, and I really don't know. But it spawned an investigation from our office, where we went through dockets of almost every foreclosure case in the state.
And there's a lot of, especially since the subprime mortgage crisis, it's really
thousands.
I mean,
Thousands.
there was that lawyer, Stephen Baum, right?
Right. There was maybe we can drop a link in the video later on,
Yeah.
but it's there were some stories, and he made some sort of settlement with the government about various things, but there were documents and affidavits submitted to court which were untrue, and it turned out that some of them may have been made up. And so we're kind of dealing with a similar issue here.
So New York was really kind of the center of that subprime mortgage crisis. And then on top of all that, now you have this whole new separate scandal where banks are really just stealing equity from homeowners. Am I framing that correctly?
You are framing that correctly. That's what we allege in the complaint.
Wow.
And so it's not only that over $500,000, it seems, was taken from Miss Athel and Sheila Badar, but there's a certain portion of the case which is not easy to understand. But during that period of time, they were using bad math.
Well, I'm a lawyer. I don't know math. So walk us through this.
All right. So in the foreclosure process, that's funny. So when the complaint is filed in a foreclosure case, you have to go to court and you have to answer. And if no one answers, they're in default, which is most foreclosure cases in New York. Then they get summary judgment or default judgment. And then that's liability. The next step is calculating the amounts that are owed. And that's done by a referee. And then what ends up happening is a referee issues that report, says how much is owed, but it's only up to the point of the motion requesting the money at that time. So then there's a motion that gets filed, and we don't know how much interest ends up being calculated during that window when that motion's being determined.
But the referee is the one who's supposed to kind of make sure everything is done properly, right? They're the independent third party. Sorry, Mark, we're getting some comments that you have a bad echo. Is your audio okay?
My audio is okay. I think it's probably coming from the audio on your side because I have headphones in.
They said it's on your side, but let's go on.
I got no one here.
Okay, so you have these referees. These referees are supposed to do what exactly?
They're supposed to calculate the amounts that are owed. Actually, Ben, if you put headphones in, it'll go away.
Let's give this a shot.
Sorry, everybody.
No, let's keep going. This isn't gonna. We're experimenting with the live stream, but
I'm hearing the echo too.
Hold on.
Because when I speak, then it comes out of your computer.
Hold on. Let's see if we can do this live.
Better?
All right. Is everything going well? Can everyone hear this?
I can hear it. Oh, there's still an echo. It's okay.
We'll get it fixed next time.
Maybe mute your computer's audio. But while you're doing that,
let's keep going.
During that period of time, there's an amount of money that gets calculated, and the basis by which they were doing that is completely incorrect. And they ended up doing compound interest during that period of time.
So break it down for me. How does the compound interest work?
So usually when you're calculating interest in a mortgage foreclosure.
Mark, they're saying I sound fine. Mark has an echo.
There's nothing here.
We'll clean it up in the production side. Let's keep going.
I mean, I can try to do this.
All right.
Can
Let's
you
keep
hear
going. Sound good to me.
Okay.
Sounds
I'm hearing the audio coming out of your computer.
It's going real well.
That's okay. But anyway, in a mortgage foreclosure, what you need to do is you actually need to calculate based on simple interest, which is the note rate, which is, let's say your mortgage is 5%. And then there's a principal amount, which is like, let's just say it's $100,000. In a mortgage foreclosure, you get 5% per year on $100,000. And that would mean that every single year you get $5,000 in interest.
Okay. So go on. So what happened?
So what they're actually doing is they're not taking the $100,000 in principal. What they're using is a full judgment amount, which is after the case started, there's an accumulation of interest and everything else. And then they apply the face interest rate against it, which is very complicated math, but
yeah. So just break this down in simple terms. You're saying there's a judgment and there's principal and there's interest on a loan. And let's say that all comes out to $800,000. Let's keep the numbers simple. And then they're supposed to say, okay, there's $800,000. And then there might be additional interest from the original loan. But instead, they're taking that $800,000 number, which already includes interest, and they're adding on the interest from the $800,000, which is the higher number. Is that am I understanding that correctly?
Exactly. So they're using a higher basis for their calculation. And so what'll end up happening is instead of the $100,000, because judicial process in New York takes a lot longer, that basis could end up being 200,000, which could double the amount of interest they would receive during that period.
And what's so crazy about this is that most people who are not attorneys or don't know this math, they're never going to catch it. And it's this crazy interest calculation buried, which is completely illegal and is stealing people's equity.
That's right. And so that's what the class action alleges. And we have a number of different causes of action. A lot of them are punitive statutes, which means that not only would they be entitled to their actual damages, which is the amount of surplus they would have been entitled to, which we can get into, but also they could be entitled to 3 times that amount.
So I want to go back a little bit because I was reading this article and some of the things are really crazy. We're talking about that the system already has in place checks to make sure that that doesn't happen, right? Because most homeowners and even many attorneys are not intimately familiar with all those crazy interest calculations. But you had those referees, and the referees are meant to be that check because they're supposed to understand this, right? But then,
yeah, they're supposed to understand it, but they use probably the complexity of the issue and by they, I mean the banks and their attorneys, use the complexity of the issue to take advantage of the situation. And so what they'll end up doing is giving them pre-printed forms to just sign and rubber stamp and send back to the court. And what they won't know is that the math is actually wrong, but they don't know that it is wrong, because it's like saying 2+2, and this is David Brand from Gotham that said it best, is it's like putting 2+2=4 when it actually should be 3+2, but no one knows that the number is incorrect.
Wow. Wow. So I want to read a quote from this article. This was in the Gothamist, and we're going to link the whole article below in the show notes. But they said they interviewed 6 referees, and these referees all said they did not receive formal training before handling hundreds of thousands of dollars in real estate transactions. I think it's probably millions of dollars, not just hundreds of thousands.
Agreed.
Nor were they required to. In court records show they routinely approve figures submitted by lender's attorney, and even when they use a contested formula. And my question is, first of all, have you ever seen a referee on their own tell the lender before any of this started that their numbers were wrong? Or are the referees always rubber stamping what the lenders tell them?
It would appear, based on, I believe there's a comptroller's office finding from the state of New York, that they're just rubber stamping things. And the banks are taking advantage of that, because that finding was that 9 out of 10 referees' reports were incorrect.
Wow. I mean, that's 90%. That's crazy.
Yeah.
And do you have an estimate of the dollar figure that comes out to?
I don't. In the Gotham and New York Focus article, they actually mentioned that they had found through their own research over 7,000 cases. And I put a rough estimate at least 100 to 200 million dollars.
Wow. I mean, that's
but it may be more.
Yeah. That's a stunning figure.
It's terrible. It's people's equity. That's their equity in the house.
And why do you think that they've never received formal training? Is that a problem built within the system?
It's just the nature of things. I mean, really, the referees, you have to be certified by Part 36, but I'm also a Part 36 attorney. I don't get a lot of referrals.
For audience, what's Part 36?
Part 36 is just, it's when judges appoint private attorneys to oversee certain aspects of the cases so that it can be more efficient, because the judges only have so much time.
Okay.
And so, there'll be referees, receivers, all sorts of stuff, guardian ad litem, stuff like that. And when they get appointed, there's really not a ton of training about doing the math on these cases. And the banks are taking advantage of that.
So the banks are overinflating the interest, and they're using it to steal equity from homeowners, and no one knows about it.
Yeah, that's what the complaint alleges, and it's from our findings, the math is wrong.
And are there any other implications? Can there be tax consequences on this?
There could be, and that's one of the bigger things here, is that it's a possibility, and we won't know that until discovery starts. But whether or not, when there is a deficiency, meaning they didn't, when from the auction, the banks didn't recoup all their losses, whether or not the bank is marking it as a loss and saying, based on their calculations, this is how much we lost, even though we calculated it wrong. And the taxpayer, the borrower, actually got some sort of benefit from this.
Right. And the article mentioned that borrowers are being given a 1099-C from the banks saying that, oh, because we're not coming after you for this deficiency, that you got, let's say, $1 million in debt. Well, not $1 million, but let's say $250,000 in debt forgiven, because they're saying we stole this money from you, and we stole from you, and now we're saying we forgave the debt. But it's really not that much money that was forgiven, and they're paying taxes on an incorrect amount. So
that's correct.
Now they have a higher tax. So not only do they have their equity stolen, they also are getting doubly hit because they have a higher tax bill.
Right. And that's just a question right now that I don't know because we haven't been able to do discovery. But it certainly is something that is a possibility.
And do you think this was intentional?
I mean, it's hard to
I know
say.
you don't want to allege that right now.
It's hard to say, but I will say that a lot of these firms, it seems that the Gothamist article found manuals where they were training staff how to do this. It seems from the article that there were some firms that actually were taking, basically being told by the servicers to do the calculations this way. Not they're basically just they're the lawyers. They're supposed to tell people things are illegal, and they're taking what their servicers are telling them and saying like, okay, we're just going to do it this way because you said so. A good lawyer should turn around and say, no, that's illegal. I'm not going to do that.
Right. Wow.
And so is it intentional? I don't know. There's 14 firms that are implicated here, and in almost every case, they got it wrong.
Wow.
So it's either intentional or it's just systematically negligent.
And what has the reaction been since you filed the lawsuit? Have there been any changes in the way that the firms are calculating that, or are they still just completely disregarding it and doing it the same old
Some
way?
of them continue to do it the exact same way to this day. And I would hope that, the judiciary, OCA, and the legislature would step in and do something about it. I think that there certainly should be a stay of actions by these firms. But yeah, some of them have actually, Gothamist and New York Focus found that at least four of these firms have changed what they were doing since
Wow.
this. Why they started doing that, I don't know. But it's interesting.
So is that the kind of, I guess they feel they're caught between, if they change the way they do it, then they're going to get accused of, oh, you guys knew it was bad, and now that you got caught, you're doing it right. So it's kind of an admission of guilt. But if they keep doing it the old way, they're going to get accused of, oh, you guys are still stealing from everybody. So
it is certainly a dilemma that I would not want to be in.
So what is the status now? How many different actual class actions have there been? Let's start with that. Is there one class action? Did you file multiple class actions?
There are currently 5 class actions. There will be a 6th incoming next week. And to go back to answer your question, there has been some interest from the day after the story broke about this case and the investigation by Gothamist and New York Focus. Senator Myrie from Brooklyn, a state senator, came in and he introduced a bill to attempt to rectify some of these issues. It's obviously still pending, and the session hasn't started until January, but I've had discussions with Senator Myrie, and he's very interested in attacking this issue and solving the problem for consumers and homeowners.
Do you think that the answer is a legislative fix, or the law is already good enough, but people just need to have more oversight?
I think the law is good as is. It's been very clear that you can't charge compound interest on a residential foreclosure. That's been the case for eons. The only thing that I think would require a legislative fix, which I talked to Senator Myrie about, would be to actually put the actual wording of the forms that exist to this day in the statute, as they do for predicate notices in foreclosure. Put the exact wording of the form in the statute, and if a bank or their attorneys don't follow it, they get sanctioned for it. Their motion gets denied. They don't get their money.
Well, hitting them where it hurts.
Exactly.
That's always the great motive to get it right. Do you see any hope for the future? Where do you see things going from here?
I mean, I through practicing have grown to be a little pessimistic of the legal process in foreclosure. I think once there's a resolution to this case, I think that that will just start a new thing that we won't discover for a while. I hope it won't, for the sake of New Yorkers, but I don't know. It seems to keep happening again and again and again.
And if you know, is this a problem only in New York or is it across the country?
That's a great question. A lot of these firms that are implicated in this are national firms in 30 to 40 states. And so if they're doing it here and given the opportunity to do it in a different state, I think that they will, especially since some of the servicers who are national servicers are calling the shots and telling people what to do.
Wow. And if you know, are the laws similar in other states as New York in terms of that interest calculation?
Yeah, I mean, simple interest calculation in foreclosure is nothing new. It's the same in most states that you charge simple interest before judgment, statutory interest after.
And do other states have the same kind of referee process? We have that independent third party who's
it's a difference between non-judicial and judicial states. In most states, it's judicial, and then the judge just kind of makes a decision on the spot, like in New Jersey. But in some states, they do refer to a referee or what's called a JHO, a judicial hearing officer.
Yeah. And if the referees get more training, is that going to help, or is it going to be just the same problem? They don't care. They just want to rubber stamp what the lender tells them and just collect their commission and go on their way.
I mean, they only make $300, so it's hard for me to believe they're going to pay too much attention.
So why do they even do this for $300? I mean, do you think maybe we should have more of a public position for it, where they're kind of a government employee as opposed to this private quasi?
I mean, it could be, I've rattled this around my brain. It could be that the government could have their own calculator that the court just inputs the numbers into. But I really don't know what would be a good fix for this, given the number of foreclosures, especially in New York. I really don't know what the quick fix would be, but it's really not that difficult of math. And if there was a little bit of competent judicial oversight, I think it would resolve itself.
I mean, I think part of the issue is that the courts are so overwhelmed and so backed up. It's causing a massive strain on the system. So,
right.
Do you have any
ideas? Which is why there are people that are taking advantage of it, and this kind of stuff happens because they know that they can get away with it.
What do you think can be done as going forward in either New York or any other states, or any general policy ideas you have?
Nothing other than people just need to pay attention. Because even in this case, foreclosure practitioners, really, I have to explain to them 3 or 4 times before they understand what's going on. But once they do, they are blown away.
And what kind of advice do you have for an individual homeowner? Let's say they don't have an attorney, their property is going to auction. Do you have any kind of simple suggestions, practical tips that they can look out for to make sure that
speak to an attorney, obviously?
Well, that actually brings me to my next point. Is there any, you set up a special website for this, right?
Yeah, at our website, abwpllc.com, there's a tab at the top called the Foreclosure Justice Project. And it kind of explains the issue in the class action, and it also gives you an opportunity to tell us whether or not you've been affected.
Okay. And we're going to link that
free of charge. We'll tell you what's going on.
Okay. And we're going to link that in the description below, so you all will have that. All right. Look, I know you got to pick up your kids, and
I do.
if you charged us your hourly rate, we would not be able to afford it. So
for you, Ben, it's free.
You shouldn't tell our audience that. Any closing thoughts before we?
No, I really appreciate you having me on the show. I do want to thank David Brand and Chris Bragg from New York Focus and Gothamist. I obviously want to thank the team at ABW. They've been a
Big
great
shout
help.
out.
Yeah, Tim, Jacob, and all the team there. And I couldn't do it without them. But really, more than anything, if you've been affected by this, if you lost your house in an auction, please give our office a call. I'll tell you whether or not you've been affected by this impropriety.
All right. And again, everything is in the show notes below. Mark, thanks for coming on. Thanks everyone for tuning in. And we're going to do a recap coming up after this, but that's all we got for now. And everybody, thanks for joining. We'll see everyone later.
All right, thanks.